Thank you. The next item of business is a debate on motion 20485 in the name of Richard Lochhead on the Digital Asset Scotland Bill at stage 1. Excuse me, I would invite those members who would wish to speak in the debate to please press their request to speak buttons, and I call on Minister Richard Lochhead to speak to and to move the motion. Around 7 minutes, please.
Thank you, Deputy Presiding Officer. This bill, as I will refer to again in a few moments, is really about the fast-changing world in which we live and the fact that our world is becoming a lot more digital. And the Digital Asset Scotland Bill implements key recommendations made by the Digital Assets in Scots Private Law Expert Reference Group, which was chaired by the Right Honourable Lord Hodge. So in 2023, the Expert Reference Group reported to Scottish Ministers that primary legislation was necessary to clarify the status of digital assets as objects of property in Scots law, and for that legislation to set out basic provisions on how ownership of digital assets can be acquired. Legislation was deemed necessary due to a lack of substantive case law from the Scottish courts to provide the legal answers required in ownership of digital assets, and this continues to be so. Emerging technologies and innovations such as distributed ledger technologies have given rise to these assets and which are not readily incorporated by existing classifications of property under Scots law. So the identified need for primary legislation has been well supported by respondents to the Scottish Government's public consultation, as well as witnesses providing evidence to the Economy and Fair Work Committee. The bill addresses the current lack of clarity around the legal status of digital assets by providing a necessary legislative foundation in Scots law. So in doing so, Scots law will be better equipped to accommodate the modern business practices that are already in existence in our country. Digital assets are used for a wide range of purposes, from payments and investments to innovative financial products and services by both businesses and individuals. With these assets becoming ever more integrated into our financial markets, providing greater legal certainty for those choosing to engage with them is becoming, of course, increasingly important. With estimates that the value of the blockchain technology market in Scotland, to give one big example, is likely to reach £4.48 billion by 2030, the Scottish Government is therefore focused on building an environment where businesses can flourish, encourage innovation and help boost economic growth. It's not just businesses embracing digital assets. The crypto asset market, the largest category of digital assets, is currently worth around £2.42 trillion. We are already seeing an increasing uptake of all of that amongst the public. And I was pretty astonished, as I'm sure others were, perhaps in the committee in particular, to learn that around 12% of UK adults now hold crypto assets. I think that's around 500,000 adult Scots. It is important to therefore be clear at the outset that the bill has a deliberately narrow scope of application. It's a short piece of legislation, just 9 sections long, that is restricted to clarifying that certain digital assets have property status in Scots law. So it achieves this by confirming what is meant by a digital asset for the purposes of the bill, by categorising these digital assets as incorporeal movable property, and finally by weaving how digital assets are acquired and transferred into well-established common law rules, and in doing so also reflecting existing commercial practices in relation to the acquisition and transfer of digital assets. So this includes a provision that will extend protections to good faith acquirers who have obtained a digital asset in exchange for value from a person who, unbeknown to the good faith acquirer, held a defective title to the asset. I am aware that some stakeholders identified other areas of law, such as diligence and insolvency, where there is likely to be engagement with digital assets that could benefit from reform. However, most stated that this bill was not the place to deliver any such reform, and noting that insolvency is largely a reserved matter in any case. So ministers clearly agree with that. And ministers are of the view that where further changes may be beneficial, that it's appropriate for these to be developed and formed by consultation specific to these relevant devolved areas of law affected and by engagement with all the key stakeholders in the respective areas. So while some may have wanted the bill to go further, I am aware of views expressed during evidence sessions at the committee for consideration to be given to the exclusion of certain digital things from the application of the bill, such as electronic trade documents and voluntary carbon credits as well. So the Scottish Government, of course, will reflect on all the views, particularly the recommendations from the committee, but all the views we hear today from members at stage 1. And where appropriate, we will, of course, keep our minds open to amendments at stage 2, but we'll see how that unravels over in response to this debate in the next few days. So we are committed to working with Parliament and stakeholders to ensure this legislation is effective and fit for purpose, but also as technologically neutral as possible to help keep it up to date and being able to keep pace with emerging innovations as well. So overall, having listened to the Stage 1 evidence and considered the Stage 1 report from the committee, I'm very pleased there is a broad consensus on the approach taken in the bill, and I welcome the committee's recommendation that the Parliament agrees to the general principles of the bill. So finally, just before I conclude, I just want to put on record my thanks to the Expert Reference Group for all their considerable work that went into analysing the legal landscape and formulating the recommendations for primary legislation. I also want to thank in particular its chair, the Right Honourable Lord Hodge, but also Professor Fox of the University of Edinburgh for the time and effort they gave to both the Expert Reference Group and the Scottish Government and everyone else they've been interacting with during the development of this bill. And of course, I also want to thank those who gave evidence to the Economy and Fair Work Committee and the committee's members as well, and the clerks of the committee and others involved for all their hard work scrutinising this bill. And in that light, I move the passing of this bill at stage 1.
Thank you, Minister. I now call on Daniel Johnson to speak on behalf of the Economy and Fair Work Committee. A generous 6 minutes.
Thank you, Deputy Presiding Officer, and indeed I'm delighted we have such a packed chamber this afternoon to debate this important topic. But it is important, I think, for many of the reasons the Minister just set out. And just as he thanked people in his contribution, can I thank, first of all, my fellow committee members. I think we can all agree this has been a very interesting topic, but one that we have had to get our heads around a great deal of terminology and avoid going down rabbit holes. And I think that we all concluded that this was an important bit of legislation. Can I thank our clerks for their diligent assistance in that work? Can I thank everyone that both responded to our call for evidence and indeed provided evidence during our evidence sessions? And can I also, and slightly unusually, thank the Bill team from the Scottish Government, who I know are in the chamber, at the back of the chamber this afternoon, who took a great deal of interest as we were taking evidence. And actually, we're very grateful and appreciative of that. Now, I don't intend to cover every recommendation of the report. Instead, what I'd like to do is focus on the purpose, definitions and key observations that we took. As the Minister pointed out, the Digital Assets Scotland Bill is a very technical but necessary piece of legislation arising out of an identified gap identified by the Expert Reference Group that we need to ensure that Scots law keeps pace with digital technology, given the very significant increases in holding that, and because that Scots law, unlike other jurisdictions, hasn't had the body of case law that might enable it to do so, and indeed given the fact that the UK Government has legislated in England and Wales and Northern Ireland through the Property of Digital Assets, etc. Act of 2025. So, again, not wishing to see gaps emerge between the different jurisdictions in the United Kingdom. So this bill sets out a definition of digital assets, how they are to be treated for Scots law, and how they can be acquired and transferred. So it's worth taking time just to go through that definition. The Section 1 of the bill defines a digital asset as something that arises from an electronic system which makes it rivalrous and exists separately from that legal system. Now, we spent a bit of time interrogating this concept of rivalrous, which has a clear understanding amongst the legal community, although this is being introduced into Scots law. And critical to that is the understanding that for something to be rivalrous, it is something that is discrete, that cannot be used more than once, and there is clear control. So a car or an apple can be rivalrous, i.e. only one person can be in control or own or be using the car at one time, or an apple, for example, which can be consumed. And that is unlike other electronic things such as a PDF file or a JPEG file, which can be reproduced without the initial person's consent or awareness. The other critical element is that in order for something to be counted as a digital asset, it must have a reliable and immutable record of transactions that prevents someone else from using or transferring that asset more than once. And indeed on this, we had some debate regarding that nature of immutability, whether or not something had to be absolutely immutable to be considered, or whether or not, because of the electronic nature of these assets, there was some ambiguity. And again, I think that is something that we would wish the government to note and consider, certainly within guidance. Finally, there is the fact that it must be independent of the legal system for an asset to be considered a digital asset, so that such a thing would still exist even if the legal system disappeared. And now some witnesses question whether anything in Scotland can truly exist independently of the law. But the committee accepts that the bill's definition provides a workable framework for lawyers and the industry. A number of witnesses did state that there should be explicit exclusions, particularly so that we don't inadvertently create things or to be digital assets inadvertently. For example, carbon credits was one example of something that could fall into that category. Likewise, we heard that uncertificated securities traded through the CREST system may be excluded for those reasons as well. So the committee recognises the risks and calls on the Scottish Government to consider whether exclusions are necessary and to bring forward amendments at stage 2 as appropriate. A further area for scrutiny was the treatment of ownership and exclusive control. Section 3 creates a presumption that the person with exclusive control of a digital asset owns it. Section 5 explains that control means being able to initiate, transfer or divest an asset entirely. And in so doing, the bill classifies digital assets as incorporeal, movable property, but treats them like corporeal property for the purposes of acquisition and transfer. Now, we heard that this could be confusing and jarring, and we note the Scottish Government's explanation that this is necessary to allow concepts such as possession and delivery to operate in a digital context. But there are practical challenges, such as the fact that some digital assets have shared key arrangements, or that someone may have exclusive control of an asset but they do not own it due to workplace settings and other practical considerations. So we note that the bill defines control and exclusive control, but we also draw attention to the evidence that we heard that this may be at odds with what happens in practice. And again, we suggest that this is an area where clear guidance is important. The bill introduces an important departure from traditional Scots law in that it allows a person who acquires a digital asset in good faith and for value becomes its owner, even if the seller acted improperly. This is a departure from the long-standing principle that no one can give what they do not have. And we heard that protecting good faith acquirers could undermine consumer confidence in a sector already vulnerable to fraud. And so we have asked the Scottish Government to review protections and remedies to those affected. Briefly, I would just want to name-check some other critical elements that we heard evidence on, such as there was a concern that there had not been greater consideration about the wider environmental impacts that increasing use of technology can bring about. We also heard that given the creation of a UK jurisdiction task force, that there have been calls for the establishment of a separate panel of experts to advise on Scots law, and indeed ensuring that there is also representation on that UK jurisdiction task force for Scots law. We also heard about international examples such as Australia and Liechtenstein and the United States, which have much more specific focus on issues such as tokenisation, and we recommend that the Scottish Government maintains a watching brief on such measures and initiatives. And witnesses also called for a digital trust strategy to maximise the benefits between academia and industry as technology progresses. And lastly, we heard uncertainties around insolvency, debt enforcement and court procedures, as noted by the Minister, and using digital assets as loan security. We recommend that the Scottish Government reviews these areas with a view to future reform. And finally, I would just want to conclude by saying that the Economy and Fair Work Committee supports the general principles of the Digital Assets Scotland Bill and looks forward to stages 2 and 3 should Parliament approve the bill at decision time today. Thank you very much, Deputy Presiding Officer.
Thank you, Mr Johnson. I now call on Murdo Fraser to open on behalf of the Scottish Conservatives. A generous 5 minutes.
Thank you, Presiding Officer. Can I start by joining with the convener, who we've just heard from, and thanking all those who gave evidence to the committee, to SPICE for their advice, to our clerking team, and indeed to my fellow committee members on agreeing unanimously what was a very consensual report. As the only lawyer on the committee, I was occasionally turned to for advice, which I was ill-equipped to provide. And in that respect, I should declare my interest as a member of the Law Society of Scotland, although not currently practising. And it was a particular privilege to be able to take evidence in committee from Lord Hodge, who is Deputy President of the Supreme Court, and one of the most able Scots lawyers of the current generation. And we were very grateful for his insights. And I know that my colleague Michelle Thompson, who I don't think is in the chamber this afternoon, joined with me in admiring Lord Hodge's contribution. We've heard from the convener a very fair summary of the key issues addressed in this bill. We start by asking what exactly is a digital asset. And Section 1 of the bill describes it as a thing which arises from an electronic system which makes it rivalrous and exists separately from the legal system. I'm not sure that provides a great deal of clarity for the person in the street. So it might be easier to talk in terms of examples. A cryptocurrency is a digital asset. It does not exist in any physical form, but exists nonetheless, has value and is tradable. It is supported by an electronic system. Into the same category might fit non-fungible tokens, which members of the gaming community will be very familiar with. And what does it mean to be rivalrous? Well, something is rivalrous if only one person can use or consume it at one time. And a digital asset is deemed rivalrous because only one person can possess it at once. The necessity for this bill is simply because Scots law, as it exists currently, does not properly recognise digital assets as property, or at least did not properly define them. And it is important, as the Minister has fairly said, that the law of Scotland keeps up to date with changes in technology and provides an appropriate legal framework for those who own, possess and trade in digital assets. And as we've heard, the bill classifies digital assets as incorporeal movable property. That is property not attached to land and which does not have a physical existence. Section 1 of the bill goes on to state that in order to make a digital asset rivalrous, there must be an immutable record of transactions. So there must be a system of recording who owns that asset at any particular time. Sections 3 and 5 of the bill deal with the questions of presumption of ownership. It is presumed that somebody who has exclusive control of a digital asset owns it. In this respect, as Professor Fox said in his evidence to the committee, the bill goes further than the existing UK legislation in providing a definition of control. And that's necessary because it is not expected there will be a high level of litigation in the Scottish courts, and therefore need to be more prescriptive for the benefit of the Scottish judiciary. An important aspect of the bill is that it provides a legal framework for transacting with digital assets, classifying them as incorporeal movables generally, but for the purposes of acquisition and transfer, they are treated as corporeal. And that leads us to what is one of the most interesting aspects of the legislation, well, at least for me, which is this question of protection for an acquirer of a digital asset in good faith. And the bill sets out that somebody who acquires a digital asset in good faith and for value becomes the owner of that asset, even if the person selling to them was acting dishonestly. So, oh yes, happily give way.
Martin Whitfield. I'm very grateful to Murdo Fraser for taking the debate. In one sense, this is a cast-back to medieval England and the market overt, which if you bought during the day with everyone watching you, you actually got title even if the good was stolen. Did Murdo Fraser consider at any stage this might actually be a throwback and actually will cause problems going forward?
Murdo Fraser, and I can give you all that time back.
I'm fascinated by that reference to medieval England from Mr Whitfield, and sadly that did not form part of the committee's evidence. However, I'm sure the convener would be happy to reconvene evidence sessions so we could take evidence from Mr Whitfield on that particular point. But it's an interesting illustration. I was going to illustrate this quite important point in a different way and suggest that if, for example, the committee convener were to own extensive wealth in cryptocurrency, I do not know if that is the case in actuality, but if that were the case, and say I were an international cyber criminal and I managed to hack into his systems and seize control of his cryptocurrency, then sell it on to the minister, for example, and the minister acquires it in good faith and pays me value for it. In that case, the minister is deemed to be the true owner, and he acquires good title to that cryptocurrency. Now, that's not an uncontroversial choice to make, because some of who gave the committee evidence felt that was unfair. In those circumstances, it would be unfair to the committee convener. He has been deprived of his asset, and he's done nothing wrong. He has been the victim of a cyber criminal. Now, in theory, the true owner of the property, in this case the convener, has a claim against me for recovery of his value. But of course I am an international cyber criminal hiding behind the World Wide Web anywhere and untraceable. So the true owner has been deprived of his asset and has no effective remedy. Now, the reason the bill took the approach it does was explained by Lord Hodge as a means to ensure that digital assets could be traded, and there would not be an undue requirement on the purchaser, in this case the minister, to conduct due diligence as to the validity of the seller's title. And the committee did accept this argument, but we did observe this is a controversial matter, and the definition of good faith in the bill is potentially a troublesome one. And there's an issue, therefore, we felt the Scottish Government should keep under review, as indeed should be the question of a remedy to somebody who has been deprived of their unlawful assets, deprived of their assets unlawfully. And the Faculty of Advocates expressed the view that the drafting of the good faith provision was ineffective, and this should be reconsidered. So the committee accepted the bill is limited in its reach, and there are a number of issues which will need to be considered in future by Parliament. One of these is private international law, which is where there is an international dimension to the question of ownership. The law of which countries should apply to a transaction between individuals based in different jurisdictions. And what should happen where, for example, a person dies holding digital assets, what is deemed to be the location of those assets, and what laws of succession should apply. And there are also, as we have heard, issues around insolvency, which have not been resolved in this bill and will be required to be addressed at some future point. So in conclusion, Presiding Officer, this bill is not the final word when it comes to the legislation on digital assets. It is a useful starting point. I very much look forward to future bills that we can get into on this very important topic. The Scottish Conservatives will be very happy to support this bill at stage 1. Thank you.
Thank you, Mr Fraser. And I call Martin Whitfield a generous 4 minutes. Mr Whitfield.
I'm very grateful, Deputy Presiding Officer, and it is a privilege to open this debate on behalf of Scottish Labour and to indeed echo the previous contribution. We will be supporting this at stage 1. And it is right that we address this because the law has not kept pace with the rapid evolution of digital technology, and Scotland now faces a level of legal uncertainty that is neither sustainable nor actually acceptable for individuals, businesses or indeed the wider economy. Reference has already been made to the expert reference group and indeed to the submissions from those including Law Society of Scotland, where it was stressed we can't rely on the slow case-by-case development of Scots common law to resolve complex, novel questions about digital property, but it also means we lose the opportunity for considered or time-considered views on what the answer should be, and we are stepping forward at a level of pace on which there will be reliance, indeed, on those that sat and guided the expert reference group and others, or there is a risk of an incoherency going forward. The overarching purpose is clear of this bill: to confirm that certain digital assets are capable of being owned in Scots law and establish the rules governing their recognition, control and transfer. But if we are to legislate with clarity and foresight, we must also grapple honestly with the conceptual foundations of this bill, which we have already delved into, I would say undergrowth, but that's perhaps unfair, delved around the roundabout of understanding it. The characteristics of rivalness and independent existence, grounded on the work that the Law Commission and reflected in recent case law, which I think explains in a more understandable way what rivalness means in R versus Lakeman in the Court of Appeal, where discussion was had about virtual in-game currency. And this was recognised as being an asset because its use by one person necessarily prevented the use by another. And this is an essential distinction between mere data, referred to in the convener's submission as the PDF, and true digital assets. But the Law Society of Scotland raises the important point of the requirement for the immutable record risk being too closely tied to one technological model, the standard blockchain, which I think people have a growing understanding of. But this itself may inadvertently exclude other systems that are being developed that allow authorised modifications, for example, to correct a genuine error. That is why the technological neutrality must be safeguarded in this bill as we progress. Deputy Presiding Officer, the bill seeks to offer clarity on ownership, control and transfer, and much of this is welcome. The Law Society of Scotland rightly cautions that treating digital assets as corporeal movables for the purposes of acquisition can cause future uncertainty, and it would be unfortunate if a device intended to simplify ownership actually complicates the situation, particularly with regard, as we've already heard, insolvency, indeed property doctrines and the rules governing the incorporeal rights that exist at the moment. A more direct approach, linking transfer to the intention to transfer ownership and the transfer of exclusive control, may warrant reflection at stage 2. This is not an argument against the bill, but a reminder that precision matters, particularly with regard to our private law system. There is a strong case for specific carve-outs, which have been mentioned, shared by the Committee, Spice and indeed the Law Society of Scotland again. Assets such as electronic trade documents under the 2023 Act, uncertified securities under existing UK regulations and financial collateral under the movable transaction regime, already governed by detailed statutory framework, bringing them within the scope of the bill risks creating conflict, uncertainty and unintended consequences. The Government should therefore confirm whether it intends to pursue explicit exclusions or statutory instrument powers to clarify the scope of the bill as technology develops. I have the great pleasure of closing on behalf of Scottish Labour, so I can account. We will again visit the market overt and the question of ownership at that stage, but I confirm we will be supporting the bill at this stage. I'm grateful, Deputy Presiding Officer.
I detect a frisson of excitement around the chamber. I now call Lorna Slater. Again, a generous 4 minutes. Ms Slater.
Thank you, Presiding Officer. The Digital Assets Scotland Bill is a narrow bill which defines the existence of digital assets in Scottish law. This is clearly needed. Like it or not, digital assets from cryptocurrencies to tokenised records are now a part of how some individuals and businesses operate. Yet until now, their status in Scots private law has remained uncertain. This bill clarifies that digital assets are capable of being treated as property and owned within our legal framework. By establishing clear definitions, including the requirement that digital assets be rivalrous and capable of being recorded immutably within an electronic system, the bill attempts to provide a foundation for legal certainty and investor confidence. This is necessary because, as colleagues have mentioned, of the absence of a body of case law to cover the matter in Scotland. This bill responds to expert recommendations from the Digital Assets in Scots Private Law Expert Reference Group and others. Their work has highlighted the gaps, the risks and the practical challenges that arise when attempting to categorise digital assets within our long-standing legal framework. The bill draws directly on several of their recommendations, especially around defining digital assets and clarifying the principles of ownership and control, and their expertise has shaped much of the bill's structure and rationale. The bill seeks to be technology neutral and future-proof, establishing a legal baseline that will then need to have frameworks of regulation and guidance built on top of it. Digital assets are evolving rapidly, and our legislative response will need to be sufficiently dynamic to manage the risks that increased use and legitimacy of digital assets, such as blockchain-based currencies, bring. I believe that such currencies, unregulated, present significant risks to individual investors and to the structure of our banking system, and that robust regulation will be required to mitigate these risks. The Scottish Government, like other governments around the world, will need to be informed and proactive to keep ahead of these risks. They are too great and too closely linked with fundamental elements of our economy to wait for a crisis to happen before regulations are brought. I also recognise that digital assets is a very broad category of what this bill allows us to legally consider things which can have a positive and constructive impacts on our society. I'm sure my colleagues share my distress at the energy-intensive nature, for example, of Bitcoin mining. At a time when we are racing to electrify our industry and transport to try to keep ahead of a collapsing climate, that so much energy is being used to generate speculative assets which can be used to avoid taxation, to bypass legislative safeguards, and otherwise undermine the reliable and transparent operation of our economy, is horrifying. It would be useful to understand from the Scottish Government what devolved powers, if any, the Scottish Government has in this space to bring regulations and to diverge from the rest of the UK, and I look forward to asking questions about this at stage 2 of the bill. The Scottish Greens intend to support this bill at stage 1, but we expect the Scottish Government to move quickly in providing guidance and further legislation in this space to address the broader risks that digital assets present. Thank you, Presiding Officer.
Thank you, Ms Slater. We move to the open debate. I call first Kevin Stewart to be followed by Willie Coffey. Around 4 minutes. Mr Stewart.
Thank you, Presiding Officer. And can I first of all start by thanking everyone who has been involved in the scrutiny of this bill. And like the convener, I'd like to thank the Bill team, a very assiduous Bill team, in my opinion. I'm pleased to speak in support of the general principles of the Digital Assets Scotland Bill. This bill recognises a simple but crucial reality. Value today is increasingly held, transferred and secured digitally. Whether that value exists as a crypto asset in a public blockchain, a tokenised security or a digital representation of a real-world asset, Scots law must be able to recognise it as property. Digital assets are sometimes spoken about as if they exist only in theory, but in practice they are secured by cryptography, recorded in distributed ledgers and controlled through private keys. Ownership, in functional terms, is exercised by the ability to control and transfer an asset on a blockchain network. And millions of transactions occur daily on decentralised systems that operate continuously without intermediaries and across borders. The law cannot afford to treat these assets as intangible curiosities when they are already functioning as stores of value and mediums of exchange. Blockchain and digital asset infrastructure underpin not only cryptocurrencies but decentralised finance, tokenised assets and programmable financial instruments. With estimates suggesting that blockchain technology market could be worth £4.48 billion to Scotland by 2030, legal certainty becomes competitive advantage. Jurisdictions that provide clarity on ownership, custody and transfer will attract developers, fintech startups, asset managers and institutional capital. This bill positions Scotland to compete on that basis. However, Scots property law was developed for a world of physical possession and paper-based rights, and digital assets do not fit neatly into existing categories such as corporeal movables or traditional incorporeal rights. A crypto asset is not a physical thing, nor is it simply a contractual right against another party. And this mismatch creates uncertainty that this bill seeks to resolve. Without clear recognition as property, parties face risk in areas such as custody, lending and succession. As such, businesses may avoid Scots law altogether, while individuals may be left without clear legal remedies. So by confirming digital assets as property, the bill supports critical market functions such as custody arrangements, asset management and secure transfer. It provides the legal underpinning for regulated custodians, institutional investors and fintech firms operating in areas such as tokenisation and decentralised finance. Importantly, it also provides reassurance to individuals who hold digital assets directly, often through self-custody, that the law recognises those assets as something they can own and protect. Presiding Officer, this bill is about future-proofing Scots law without over-legislating. It provides certainty without rigidity and clarity without constraining innovation. By confirming that digital assets are capable of ownership, we ensure that long-standing legal principles continue to apply in a digital context. As a member of the Economy and Fair Work Committee, I believe that this bill represents a sensible, informed and necessary step forward, and I support the motion that is before the Parliament. Thank you.
Thank you. I now call Willie Coffey, again around 4 minutes. Mr Coffey.
Thanks very much, Presiding Officer. I thought I had seen the shortest bill in my time in Parliament when I saw the Community Wealth Building Bill. But this one is even shorter, set out in only 3 pages and 9 paragraphs. But its implications are far-reaching, and it's perhaps no surprise that the committee managed to write a 38-page report about it. A testament, though, to the thoroughness of committee members to consider all the related issues. For the first time, private law in Scotland will establish that digital assets are objects of property and can be treated as such and capable of being owned. That's it, basically. I probably won't get the chance to do this again, but the opening paragraph in the bill is a joy to behold for me. It was pretty daunting to read it, at least to me, but when it said, a digital asset is a thing that arises from an electronic system that makes it rivalrous, can't be used more than once, and an electronic system makes a thing rivalrous if the system maintains an immutable record of transactions in relation to the thing, and that the record is used to ensure that when a person transacts in relation to the thing, like spending or transferring it, the person loses the ability to transact in relation to the thing in that way again. I just love that definition. In other words, Presiding Officer, it's unique, and once a transaction is done, it's done. As I said, the implications of it all are far-reaching and will mean that Scotland's legal system can provide legal certainty when managing digital assets in the future. Digital assets are becoming an increasingly important and established part of global financial services. They're recorded, traded, transferred and so on digitally by means of digital ledgers, usually called blockchain, and their increasing use and value is evident. We've got a very strong fintech sector in Scotland, including specialist digital asset trading businesses worth around £2 billion to the economy at the moment, employing over 11,000 people across 260-odd companies. And the Minister reminded us that it's estimated that the value of this blockchain technology market to Scotland will reach about £4.5 billion by 2030. So the need for the bill is pretty clear, and it gives Scotland the ability to adapt to future emerging trends in the digital space, a point acknowledged early in the report. Our committee was extremely forensic in scrutinising the bill itself, and so too were our witnesses, who tried their best to help us through some of the complexities that arose. The concept of immutability, mentioned by some of the members, meaning that a digital asset cannot be changed, got quite a bit of attention, and some contrasting opinion came from our learned professors. Some thought that absolute immutability was not helpful, and in cases of potential fraud, there had to be an ability to correct a digital record from unauthorised or distorted changes. Others suggested that absolute immutability was in fact essential, and that systems that permitted changes to be made should be excluded. Others preferred to describe this term in terms of integrity of these records, enabling a degree of flexibility, but at the same time being secure from unauthorised alteration. So you can see, Presiding Officer, that we were grappling with some fairly complex and technical issues in the bill. In the time-honoured manner and in a masterstroke of wisdom, the committee recommended that the government should monitor developments in this area, working with industry, academia and the like to develop the guidance and interpretation of these important issues as they apply to digital assets. Section 3 of the bill defines what is meant by ownership of a digital asset and defines it as having exclusive control of it. Section 5 says that a person has control of the asset if he or she has the ability to transfer it. And exclusive control rests with a person who has sole control of the asset. Now, there was quite a bit of discussion around this too, touching on what we meant by control, exclusive or not. An example was offered where a person could have exclusive control of something but not actually own it, for example, in a work context. And the opposite, where a person owned a digital asset but didn't have exclusive control of it, for example, a shared private key, for example. And again, the committee opted to draw the government's attention to these issues and to address them in the accompanying guidance to the bill. Presiding Officer, the bill is indeed very short but incredibly significant for Scotland moving forward in the digital asset space. In this brief glimpse, I've mentioned a couple of issues today on immutability and ownership and control, and these were given considerable attention by all of my committee colleagues. I hope that in taking the bill through stages 2 and 3, that the government is able to clarify these important matters and that the bill will be strengthened as a result. Thank you.
Thank you, Mr Coffey. We now move to wind-up speeches, and I call first Lorna Slater. Around 4 minutes, please.
In concluding, Presiding Officer, I would like to indicate my support for the Stage 1 report of the Committee for Economy and Fair Work. This report notes the potential for digital technology to have wide-ranging impacts across society. There are both economic benefits and opportunities, but also risks for Scotland. The committee calls on the Scottish Government to maintain a proactive approach, to engage with changes and to adopt approaches to ensure that benefits are maximised and risks are mitigated as technology changes. The committee recommends that the Scottish Government works with stakeholders to ensure Scottish interests are represented on the UK Jurisdiction Task Force, as well as any other relevant expert group which may be established. In addition, the committee calls for the Scottish Government to establish a Scottish panel of experts to advise the courts, businesses and the legal sector on emerging digital technology issues in Scotland. The committee acknowledges that further legislation is inevitable given the pace of change in the digital world. The committee believes that the important issues of definition and application should not be left to subordinate legislation and therefore did not recommend the inclusion of additional regulation-making powers in the bill. The committee acknowledges the Scottish Government's stated intention and narrow purpose of the bill and supports this approach to ensure legal recognition in Scots law of digital assets. Thank you, Presiding Officer.
Thank you. And I call Martin Whitfield again. Around 4 minutes. Mr Whitfield.
I'm very grateful, Deputy Presiding Officer. Now, can I also echo my thanks to all of those who've been involved, both those who submitted evidence absolutely to the committee, those that support the committee, and to the government and drafters in respect of what is possibly one of the shortest bills that has made its way through. But a bill, no matter how short, still needs the right level of scrutiny. And it is important, as we increasingly move into a digital age, that scrutiny exists. And it allows me to contemporise on the discussion about market overt. And I am considered to do this, but for a very practical reason. If we cast our minds back in history to medieval times, where people lived locally, travelled by foot or horse, there were nefarious individuals who stole from some people and sought to profit by selling it to others. The challenge being that the knowledge of whether something was stolen, the knowledge of the person that was selling it, was very hard for the purchaser to understand. And so what developed was a legal fiction where if it was bought in a certain market between the hours of daylight in public, then ownership would transfer. And the reason for that rests, and I reference it because of the challenge that we have here, references it as to the transparency of ownership and the passage and the need to have commerce that works. And so the medieval answer was, in a certain market, you get good ownership. Today, the answer with the digital bill in front of us is, oh, you'll be all right. But there has been evidence submitted to the committee, and indeed the committee report makes reference to this, and I think it is an important element that the government look at for stage 2, about the authority for doing that, because that single problem actually sits at the heart of a number of areas where requests for guidance, understanding and actually the view that the government intends to take is an important one. There are other areas that need to, again, be looked at. And in conclusion, I would seek the government's assurance that they are going to reach out, provide guidance, do the thinking, in particular about the wider questions that surround digital assets. We've already talked about the situation with regard to insolvency and the reserved nature of much of that. But there is the question of international law, there is the question of diligence, there is the question of security and borrowing over digital assets, there is the question of civil procedure and also the taxation. I welcome the committee's call for a programme of future reform and echo calls for Scotland to remain aligned with developments across the UK and internationally. I again confirm that Scottish Labour will support the general principles of the bill, but I do urge the Scottish Government to act upon the concerns set out by the Law Society of Scotland, the committee and others to ensure that this legislation is not only workable on paper, but effective, fair and future-proofed going forward. I'm grateful, Deputy Presiding Officer.
Thank you, Mr Whitfield. I now call on Stephen Kerr, again, around 4 minutes. Mr Kerr.
Presiding Officer, this has actually been quite an enjoyable debate in many ways. Okay, maybe I'm being told I've gone too far already. But it has been in many ways. I mean, Daniel Johnson started off by warning us about the dangers of rabbit holes, and then Martin Whitfield got up and took us to medieval England. I mean, that's a rabbit hole, if I've ever heard one. I mean, and he continued down the rabbit hole when he got a second chance to speak, which is remarkable. Also, I remember I had to get up in this Parliament once and announce I am not a potato, which may be the only thing that anyone will remember about my time in the Scottish Parliament. I don't know. But I never thought I'd hear the day when a member would get up and say, I'm an international cyber criminal. But that's what Murdo Fraser has announced this afternoon, and because it will appear in the official record, I think that probably is court evidence, just in case anyone's listening. Guilty, I'm an international cyber criminal, he said. But, you know, in all seriousness, I do support the general principles of the bill, and I do so having been directly involved as a committee member in most of the, not all of the Stage 1 committee scrutiny. But this is a complex and highly specialised area, and it's probably obvious to all of my colleagues, it's certainly obvious to me, that I'm not an expert in digital assets. And when Martin Whitfield announced that there was a growing understanding of blockchain, I must confess I did shrink a little in my seat, because I have to confess I do not have a growing understanding of blockchain, but I am open to tutorials. If anyone is willing to sit down and take me through the Dummy's Guide to Blockchain. Oh, there's a number of members which are happy to give way to Martin Whitfield.
Martin Whitfield.
Yeah, I'm very grateful to the member giving way, not by way of tutorial, but by way of referring back to the fact that actually blockchain is referred to a lot and is used as a sort of basis expectation. But there are changes in technology that is making even blockchain antiquated, and that's what this bill needs to address going forward.
Stephen Kerr.
Well, that, Presiding Officer, is cold comfort. Just when I thought I was going to get a tutorial on blockchain, he tells me that's now out of date. I think Daniel Johnson also wanted to come in.
Daniel Johnson.
Although I suspect that the member may be just trying to fill his time by encouraging others to do it for him. But I wonder if actually he has demonstrated the need for this bill, because most people probably are unaware about how these things operate. But there will be people in Scotland who are holding these assets who may well end up being in dispute. Maybe that will be businesses, maybe it will be a matter of divorce cases, and in which case we really, in those situations, will need Scots law to be able to understand and incorporate digital assets so we can settle these things fairly. I wonder if you'd agree that that's fundamentally what we're here to do.
Stephen Kerr.
I do agree with him on everything he said, but not the bit before when he said I was inviting people to contribute to fill up my time. I'm more than capable, as I think the Parliament knows, of filling up any of the speaking time that I am generously permitted to have. But I agree with what Daniel Johnson said, but we are nevertheless, as he says, we're dealing with unfamiliar concepts, unfamiliar language, legal language. We've got learned colleagues, or a learned colleague in the committee, which is good to have. But we are living in a technologically accelerating world, and that's precisely why the evidence sessions, I think Willie Coffey was right when he said that the witnesses did their best to help us understand, and I think they did, and the sessions actually were very, very helpful, and the quality of the evidence was superlative. And I also want to pay tribute to my colleagues in the committee for the quality of the scrutiny. Because, frankly, under the convenership of Daniel Johnson and our Deputy Convener, Michelle Thompson, I felt that there was a seriousness, a discipline and an intellectual rigour around the degree of scrutiny. And I think Kevin Stewart mentioned the quality of the scrutiny, and I think he's right to do so. And we did hear a wide range of evidence, and some of it was contested. There were different points of view, which is refreshing to hear. And I think the report, by the way, absolutely reflects that. And I pay tribute to the clerks, because the report itself, as I think one of the members said, I think it was Willie Coffey again, 38 pages long. I mean, I have to confess, reading it is not a leisurely read. I mean, it is a pretty difficult read. In fact, earlier on, I had said, in speaking complimentarily of the report, I had said to Murdo Fraser that I thought it was 100 pages long, and then I checked it was 38. It must have felt like it was 100 because of the density of the information it contains. So I do want to place on record my thanks for the clerks for their expert work. But this is, as I think a number of speakers have said, it is a deliberately narrow bill. It focuses on providing legal certainty in Scots law by recognising that certain digital assets are capable of being property, capable of ownership, capable of lawful transfer. And given our existing property categories predate digital technology, that clarification in law is necessary and overdue. And as a committee, we accepted that concepts such as rivalrousness and immutability, while not everyday language, are sufficiently clear to provide a workable legal framework. We also accepted that this is a framework bill and it sets foundations rather than answers every downstream question, because not only do we not know the answers, but we don't even know what the questions are that we may face in times to come. And issues such as tokenisation, environmental impact, insolvency jurisdiction and enforcement are all matters that were flagged by the committee in the report as areas where further work will be needed. And that leads me, Presiding Officer, to strike a note of caution. The pace of technological change in this area is not slowing down. It's accelerating. The committee was clear that complacency would be a mistake. And again, as other colleagues have said, if Scotland is to remain a credible and competitive legal jurisdiction for this kind of activity, and that is going to be quite a task in and of itself, given the nature of this market and where it is centred, Parliament and Government will need to stay properly advised, properly resourced and alert to what this legislation sets in train. And further legislation will be inevitable. And the capacity of this Parliament and us as parliamentarians to scrutinise it properly will be tested. Of that I have absolutely no doubt, being a current member of the committee. And I also would like to note, compliments have been paid to the Government Bill Committee, but I'd also like to point out that this may well be Richard Lochhead's last bill as a minister in charge. And if that proves to be the case, it is hard to imagine a more intricate and demanding subject on which to legislate. I'm sure he longs for a return to the UEFA Championship bill. And I recognise, though, it would be churlish to do other than say this, I recognise the work that's gone in by government and the officials of government in bringing forward this bill. And so for all of the reasons that have been outlined in my very short contribution and by the contributions of colleagues across the chamber, I'm happy to say that the Conservatives, the Conservatives will support the general principles of the bill, and I encourage Parliament to do the same.
Thank you, Mr Kerr. I call on the Minister to wind up.
Thank you, Presiding Officer, and thank you to everyone who's contributed towards this debate as well. And I'd like also to repeat my thanks to the Experts Reference Group for the work it's undertaken to inform the development of the bill, and the Economy and Fair Work Committee for its work scrutinising the bill as well. And Daniel Johnson, as chair of the committee, of course, in his speech gave a very easy-to-understand explanation of many of the concepts in this bill, so I was very grateful for that and for that to be put on the record. And on that note, I should also add my thanks, as others have done, to the bill team, because I can assure members that as a business minister dealing with quite a legalistic bill, I was often relying on my bill team to explain many of the concepts behind it to me. And even as recent as yesterday, we were discussing bored apes. And if you'd said to me I was ever going to be discussing with a bill team the concept of bored apes, I wouldn't have believed you. But of course, bored apes are non-fungible tokens known as NFTs. NFTs being digital tokens which generally regarded as cannot be exchanged with something as a similar type of token. And they are unique pieces of art. And there's thousands of them, and they're very valuable, and they can be worth thousands of pounds each. So that's what bored apes are. They're collections of these unique pieces of art. So this is the changing world in which we live, and this is why we are having this bill before us today, because we have to make sure our legislation is catching up with what's happening out there, and we can give legal certainty and sense of identifying property, which is really what this bill is all about. So digital assets are an increasingly important component of a whole range of areas, from financial services and also the daily economic life of our citizens. And by providing the greater legal certainty required on the property status of digital assets, the bill provides a significant legislative foundation for Scots law. And as I said, it will enable Scotland to not only keep pace with legislative developments in other jurisdictions, but also to take better advantage of all these economic benefits and opportunities that digital asset technologies and innovations can offer. And it's clear from today's debate there's widespread support for the general principles of the bill, and I very much welcome that. There were a couple of issues I'll quickly address in terms of carve-outs. I know that, as Daniel Johnson and other members of the committee have said, there's many recommendations from the committee to deliver good guidance on a number of issues. And, of course, we will reflect upon that and take that forward and respond to the committee in due course in terms of all the recommendations. And one issue that was raised was the prospect of carve-outs, particularly over issues like voluntary carbon credits. Voluntary carbon credits will be confirmed as objects of property if they meet the criteria within a definition of a digital asset contained in the bill, as would any other token. And as objects of property, digital assets therefore enjoy the protection of the right to the peaceful enjoyment of possessions under Article 1, Protocol 1 of the ECHR. However, as we should all remember, the right to the peaceful enjoyment of possessions is not an absolute right. So, should voluntary carbon credits meet the definition of a digital asset in the bill, they can be confirmed as objects of property. However, we'll reflect on the concerns that were expressed to the committee by some witnesses in terms of what this would mean in terms of ownership of land, etc., and the carbon credits, voluntary carbon credits that may arise from that, and we'll reflect upon that as we go towards stage 2.
Daniel Johnson.
I'm very grateful to the Minister for giving me. I mean, I think the point about the carbon credits is, yes, that was an example, but it was an example. I think the point that was being made by witnesses that there may well be things that exist either within government or elsewhere, which actually, in terms of the points about rival risks arising from an electronic system and there being an immutable record, may satisfy, and we do so inadvertently, that are actually merely records or means of recording certain things or regulating certain elements, either for government or other organisations. I wonder if the Minister would accept that point, and whether the government will undertake any work to try to identify any particular regimes that might fall into that category.
Minister.
Yes, we will look at that point and reflect upon it. And there was other issues, of course, like electronic trade documents that were mentioned as well. And I know that some academics, I think it was from the University of Aberdeen, raised concerns to the committee about that in terms of whether they should be recognised as digital assets or not. And we will again reflect on that in terms of potential carve-outs. But as I said before, we'll have to reflect on that. But as many members have said, there is a need for legislation, and The committee, of course, heard from a range of witnesses that there is a lack of legal certainty on the status of digital assets as objects of property in Scots law, and the overwhelming majority agreed that greater certainty is necessary and that this should be provided for in primary legislation. So this was reflective of the views shared by respondents to the Scottish Government's consultation, and again from members speaking in today's Stage 1 debate as well. So the need for a bill is not in doubt. This bill will put beyond doubt that certain digital things can be owned if they meet the definition of a digital asset within the bill. However, given the rapid proliferation of digital assets, we should not wait until an appropriate case is brought before the Scottish courts to confirm their legal status as objects of property. So, therefore, the bill will have the opportunity to make the law clearer, and we want to take that as a Parliament forward. So, I'm pleased the committee supports the general principle bill. I could talk for a long time, but I think I'll just bring my remarks to a close, because there's a lot of other issues in the committee's report. But I think we understand that this is required, and it's a short, sharp bill which is necessary to recognise digital assets as property in law. So, without further ado, can I just say that Scotland's independent legal system, I know we heard about medieval England earlier on, but Scotland's independent legal system and legal heritage is something we are committed to preserving, while also ensuring that Scots law remains a forward-looking and enabling environment for the technologies of tomorrow. And that's what this is all about. This bill will help us achieve that. Therefore, I urge Parliament to support the general principles of this bill, and accordingly I move the motion that Parliament agrees to the general principles of the Digital Assets Scotland Bill.
Thank you. Thank you. That concludes the debate on the Digital Assets Scotland Bill at Stage 1. I call Douglas Ross for a point of order.
Thank you very much, Presiding Officer. On Tuesday, I asked if you would suspend standing orders to allow an urgent question to be taken in this chamber on the Scottish Government's legal arguments that they had published earlier that day on their case to continue to allow biological men to be housed in the female prison estate. In responding to that point of order, you said this: "Thank you, Mr Ross, and I appreciate advance notice of your intention to raise this matter. I am not minded today to accept a motion without notice. I think my determination to ensure that all members have an opportunity to scrutinise the Government fully and regularly, whether that be through urgent questions or the selection of other questions, is very clear to Parliament." And you finished by saying, "I remind Mr Ross of the other opportunities that exist and which are available to him this week." End of quote. The next day, on Wednesday, I submitted the same question as an urgent question, which you rejected, saying it was not of sufficient urgency. However, you did wish for me to know that should I press my button at First Minister's questions, that would be an option for this to be raised. I then submitted the urgent question for a third time today, which you rejected for a third time, but based on your advice and the advice given by the Deputy Presiding Officer yesterday in the chair, I pressed my button again during First Minister's questions, and I was not called. Now, my question is, I know SNP members don't want to hear this, but my... I can't hear, sorry, Presiding Officer.
Yes, that is often...
Sorry.
That can often happen in the chamber, but do please continue, Mr Ross.
I'm grateful for that, Presiding Officer. So, you've rejected 3 urgent questions. You haven't selected the question, despite having advance notice at First Minister's questions. So we've now sat for many hours over...
Thank you, Mr Ross. I will address the points that you have made.
Could I finish my point of order, Presiding
Well,
Officer?
please finish briefly, Mr Ross.
I do appreciate the opportunity to at least finish my point of order. So, given that we have sat for...
Please identify the relevant procedure that you have an issue with.
Well, I'm asking how... First of all, if you were correct in what you said on Tuesday, that there would be other opportunities to raise this matter this week, when those opportunities were that have now been missed,
Thank you, Mr Ross.
And why, if I can finish...
I'm still not clear that you are addressing a particular procedure.
Well, the procedure is, did you incorrectly state to Parliament that there would be opportunities this week, which have now not materialised? And why have we sat as a Parliament for many hours, over 3 days, and not a single minister has been able to answer a single question because no one's been able to put them on such an important issue?
Mr. Ross.
And this is an issue that must be addressed by this Parliament.
Thank you, Mr. Ross. Thank you very much. I'm not wholly clear that we ever got to what the point of order was. I'm not wholly clear, Mr. Ross. You have had considerable time to put your point. What I would say, I appreciate that the member considers that this is an urgent matter, but the member will also understand and appreciate that the chair is required to be fair to all members in the chamber. Today and throughout this week, I have selected many matters that other members also consider to be urgent and pressing. And the member will also note that pressing the request to speak button does not guarantee that they will be called. That even the intention to do so, when confirmed in advance, does not mean that the request to speak button doesn't require to be pressed. And obviously the chair at the time will be considering a variety of factors in who they are able to call, not least the length of the session. So I probably would point the member to the fact that an opportunity is not the same as a guarantee. Where there are opportunities, the chair will always strive, I will always strive to include as many members as possible. But I cannot guarantee, Mr. Ross, that it will always be possible to prioritise your question in any one week over that of any other member. And we will move on at this point, Mr. Ross. Further to that point of order, no, Mr. Ross, I would ask you to sit down and I would ask you to remember that only yesterday I asked you to reflect on your action. Well, I'm going to call matters to a halt here in regards to this and suggest that perhaps you take a little more time to reflect, because I do not feel that you've had that opportunity adequately yet. So we're now moving on to the next item of business. Mr. Ross, we have heard enough for now and we are carrying on. We're carrying on with our business. Mr. Ross, you can either leave this here. Mr. Ross, you have not yet made it clear what your point of order is. You will have one further opportunity and then you will resume your seat. One brief further opportunity.
I'm grateful, Presiding Officer, because all I'm seeking is clarity now. Given your statement on Tuesday that there would be further opportunities this week that have not materialised, can I ask how you will view the same question being submitted next week so we can finally get answers from ministers? So I can't hear.
I am simply not going to discuss what questions may be put next week. We will continue with our business. So there are two questions to be put as a result of today's business. And I'm minded to accept a motion without notice under Rule 11.2.4 of Standing Orders that decision time be brought forward to now. And I invite the Minister for Parliamentary Business to move the motion.
With respect, Presiding Officer, moved.
Thank you. The question is that decision time be brought forward to now. Are we all agreed? We are agreed, and there are two questions to be put as a result of today's business. The first is that motion 20414, in the name of Sarah Boyack, on the Wellbeing and Sustainable Development Scotland Bill, at stage 1, be agreed. Are we all agreed? The Parliament is not agreed, therefore we will move to a vote and there will be a short suspension to allow members to access digital voting.